I see Mr. Hersey. I see Miss Ware. All right. Mr. Hersey, whenever you're ready.
Thank you. May it please the court. I'm Robert Hersey. I represent the appellant, the former husband in this case, and I will refer to the parties as former husband and former wife. I think it'd be clear that way. I would like to reserve 5 minutes for rebuttal.
Okay.
I also wanted to state that I intend to argue issue number 1, and I will rely on the argument in my brief for argument number 2.
Thank you.
But the primary issue and what we're asking the court to do is, our position is that Judge Melissa Polo erred and abused her discretion by granting the former wife's exceptions and rejecting the findings of fact and law in the General Magistrate's corrected report and recommendations dated July 31st, 2017, which conformed to a ruling of a prior trial judge, Judge Lee. Now, this case, there's a lot of facts, and I think the facts are stated and maybe even overstated in the briefs, but I will refer to them, I think, for clarity. Initially, the former—
Can I ask you a question, Mr. Hersey, first? Because when I read this, I had a hard time splitting this hair that you're getting ready to focus on, and you're going to launch into it, so I want you to help me make sure I understand it.
Sure.
So when Judge Polo followed Judge Lee, and when Judge Polo rejected the General Magistrate's report, which was based on Judge Lee's ruling, it was kind of a critical point in this case. Is that all that Judge Polo did? Because it seems like that there is the issue here about attorney's fees. Ms. Ware makes the argument that they're made pursuant to 6116. You seem to be focused on the fact that Judge Lee said that after the critical date of April the 3rd, 2014, any fees that would occur thereafter were not reasonably occurred. So arguably they're part of the contempt sanction. Am I right on that? I mean, are you focused on a successor judge overruling a previous judge?
Well,
and on the issue of fees, which are based on a contempt sanction?
well, that's part of it, but see, there was no contempt sanction because
Right. It was mooted. It was deemed to be moot, right? Because you complied, right?
Right. The issue was moot before the contempt hearing, and we had filed a motion to dismiss based on that mootness. However, it was rejected by the General Magistrate. She wanted to go ahead and hear testimony. In her report and recommendations, she held the former husband in contempt, but indicated that he had complied with the insurance notice requirement prior to the hearing. Therefore, based on that compliance, no purge is appropriate and none is ordered.
But let me ask you, do you agree that, and I think you do agree because I think you paid them, were you responsible for the former wife's fees up to the April 3rd date?
Yes, sir. We did pay those
And you
fees.
paid them, right?
Yes.
Yeah, okay.
But it was after that where there was really no justiciable issue. It was moot at that point. Now, we followed our exceptions and objections to the magistrate's report and recommendations that found the former husband in contempt. And it went to Judge Lee. Judge Lee ruled and cited case law for the proposition that, well, the magistrate found that there was compliance. The husband had complied before the contempt hearing. Therefore, the issue was moot. And she cited case law thereon. Now, at that point, she then issued an amended order which reserved the issue of attorney's fees because both parties were requesting attorney's fees. However, and I want to emphasize here that although the magistrate originally found that the former husband was in compliance before the contempt hearing, the former wife never filed any exceptions or objections to that finding and never appealed Judge Lee's ruling that the issue was moot. So, then we get into the attorney's fee hearing that was held before the magistrate after she filed her corrected report and recommendation pursuant to Judge Lee's order. After the attorney's fee hearing, she made her findings of fact and law, and said that the former husband was in compliance before the hearing on April 25th of 2014. Therefore, any fees incurred by the former wife after that date were not reasonably incurred. And sitting as a court of equity, it was within her sound discretion to issue that order.
Yeah, and I hear you that, and I read that in the briefs, of course, but Ms. Ware makes the argument that that's not relevant to a 6116 determination of need and ability for attorney's fees. I mean,
Well,
that's, and I don't mean to, I mean, we're going to hear her position in a minute. And I don't want to put words in her mouth, but as I understand it, she basically says that doesn't matter. This is a need and ability analysis. And you made it really clear in this case early on that you had the superior ability. And you know, so does it matter what, you know, what transpired after April the 3rd? After April the 3rd, the presiding judge, which is Judge Polo, is going to say, you know, who's got the need and who's got the ability, and I'm awarding fees on that basis pursuant to 61, right?
well, I'm not sure I agree with that, Your Honor, and I think
I'm
that,
just asking. I don't know what I agree with at this point. I'm just asking.
I understand. Judge Polo's not the one that awarded the amount of the fees. It went back to the magistrate. But I had the superior ability to pay. What happened was Ms. Ware issued a request for production. She wanted to get into me producing all of my financial records. She wanted to hire appraisers to appraise the homes of the parties, get into all this discovery on ability to pay. And I said, wait a minute, look, okay, they're going to find I have a superior ability to pay. So let's enter into a stipulation and avoid those additional thousands and thousands of dollars of attorney's fees and expert fees for appraisers. So we entered into the stipulation. I think the under 6116, and Ms. Ware has depended heavily on the Rosen case. But in the Rosen case, under 6116, the need and ability to pay, although is an important factor, the Supreme Court said, we resolve this conflict by pointing out that proceedings under Chapter 61 are in equity and governed by basic rules of fairness. The legislature has given trial judges wide leeway to work equity in Chapter 61 proceedings. Thus, Section 61.16 should be liberally, not restrictively, construed to allow consideration of any factor necessary to provide justice and ensure equity between the parties. Had the legislature intended to limit consideration to the financial resources of the parties, the legislature easily could have said so.
Well, Mr. Hersey, let me pause there, because I think that one thing that's maybe gotten lost here is that the legislature did give some guidance in 6116 sub 1, and it may pertain to this ruling that Judge Lee made, and the under 6116.1, it says the court may from time to time, after considering the financial resources of both parties, which ends up getting stipulated to, order a party to pay a reasonable amount for attorney's fees, suit money, et cetera, et cetera. So isn't the issue here really whether or not Judge Lee had made an adjudication that, look, anything that was incurred after compliance just wasn't reasonable?
Exactly, and that's what the general magistrate ruled, was that any fees incurred after April 3rd, 2014 were not reasonably incurred. And if you look at
Don't we have, Mr. Hersey, we do have before the trial court, there's evidence as to the reasonableness and the amount of time and the rates charged.
well, that was as far as the amount of fees, and this came after Judge Polo reversed everything that Judge Lee and the magistrate had already ruled on, which she cannot do, and which I've cited case law in my brief indicating that she exceeded her authority in doing that. But you have to look at what is reasonable, and I cited a case of Levine versus Keister, 862 Southern 2nd, 2D19-3174, 4th DCA case. And it says, in computing attorney's fees, the trial judge should determine the number of hours reasonably expended in litigation, and it goes on and on. And then it says, it is well settled that the determination of an award of attorney's fees is within the sound discretion of the trial court and will not be disturbed on appeal. Well, the magistrate ordered that and found that the fees incurred by the wife after April 3rd were not reasonably incurred. And Judge Polo had no authority to reverse that. And if we go down further, before Judge Polo, who was a successor judge, and you'll see that as we argued, this was pursuant to the former wife's exceptions to the general master's corrected report and recommendation, and where we argued, hey, it's moot, it's res judicata. The issue of mootness is res judicata. The magistrate ruled correctly, and referred to Judge Lee's order. And Judge Polo says, I don't agree with Judge Lee and the fact that the issue of insurance was moot. In fact, because it was only Mr. Hersey who was prescribed to undertake an act, and he's never complied. Well, it had already been found that Mr. Hersey had complied and that the issue was moot, and that was in the judge's order. It was res judicata. And then she says, when we argued that it was res judicata, Judge Lee ordered it. Judge Polo says, well, I'm just saying, I see it differently. And I feel that the general magistrate at the hearing on May 11th, her ruling was not supported by competent substantial evidence. She goes on to say that I don't have to accept them. I can see things differently, and reasonable minds differ. Now, as we then referred her back to Judge Lee's order, Judge Polo says, I don't agree with her decision. No. So what she did was overrule something that was already ruled on by a trial judge and by a magistrate. It was res judicata. It went unchallenged, unappealed, and decided to, in place of those findings of fact and law, supplant it with her own thoughts on it and her own adjudication of the facts. So, and I think the case law that I filed or that I cited is clear that she can't do that. In Ward versus Drones, 90 Southern 3826 3rd DCA case, the court held, once a trial court appoints a magistrate to take testimony and make findings, it loses the prerogative of substituting its judgment for that of the magistrate. And in Matos versus Matos, on page 36 of my initial brief, the court held that, and this was the 2nd DCA case, where the trial judge chooses to appoint a master to hear the testimony and make findings of fact and determinations based thereon, the trial judge loses the prerogative of substituting his judgment, call, or determination of those lawfully reached by the master. So, and then there's Garcia versus Garcia on page 37 of my brief. It says the trial court should approve the general master's factual findings and recommendations unless the master has misconceived the legal effect of the evidence. Well, the magistrate's legal effect of the evidence was based in part on Judge Lee's order, which went unchallenged and unappealed. And also the findings of the general magistrate in the original contempt hearing that the husband was in compliance was never challenged by the former wife. She never filed exceptions or objections to that. So, there's also Alvarez versus Alvarez on page 37 of my brief, that when a fact, issue, or a cause of action has been decided by a trial court of competent jurisdiction, neither of the parties involved shall be allowed to call into question and relitigate the thing decided, so long as the judgment or decree stands unreversed. So there's, I think, and then of course it's well-established law that a successor judge cannot overrule or reverse what the prior trial judge had ruled on. That has to be done by appeal, which was not done.
I think you overstate. I think that's maybe a little bit of an overstatement. There are some things that a successor trial judge can revisit under principle while staying within principles of comedy. But I hear the thrust of your argument, which is, look, this isn't one of them. This was basically a final adjudication on fees, where there was a final adjudication on what was reasonable and what the cutoff point was. That didn't go challenged, and it was not for a successor judge 2 years later to say, nope, I do think it was reasonable. I think that's what your advocacy is. I don't think that under the law there is a hard bar. Summary judgment's a good example. I mean, a successor, it's a non-final order, so a successor judge might say, you know what, I'm seeing this different, and we wouldn't necessarily say that was reversible. But I think what you're saying is that this is more like a final determination or a final adjudication on a contested issue, and you either move for rehearing or appeal it, or you live with it.
Right, and they didn't either, and there was no fraud or anything else that would take it out of the general rule that a successor judge cannot overrule or reverse what a prior judge has done. And I have cited case law in my brief on that as well.
Mr. Hersey, forgive me for interrupting you. You are into your rebuttal time, but use
Okay,
your
I'll
time
stop.
as you wish.
I'll
Yeah.
stop now. Thank you.
Okay, very good. You'll have your 5 minutes on rebuttal. Would you mute your mic, please, Mr. Hersey?
Yes.
And Ms. Ware,
Thank you, Your Honor.
let me ask you something. With all this testimony and evidence about this issue being moot, and Mr. Hersey apparently having already paid the $3,000 through this key date, as I look through the record, I am befuddled by how one can spend $30,000 to wrap up what is otherwise a moot case.
Let me start out by saying that there's been no suggestion in the appeal or really a very vigorous suggestion before the general magistrate that any of the hours were unreasonably spent. There were two hearings on exceptions, one before Judge Lee, one before Judge Polo. There were a lot of discovery issues. Mr. Hersey alluded to them. There was a fee request under 6116, which requires financial disclosure. There was a lot of efforts on that. There were hearings that were set.
But he's already he stipulates as to his superior financial situation. You know your number's 30,000. So all you really need to be spending time is with an expert to say these were reasonable hours and here's the number.
He eventually agreed. That as he pointed out, it was my discovery request and the dispute over the discovery that caused him to ultimately agree to the stipulation that he was responsible for the fees. And you can see that the fees grew over time. At the first fee hearing, the fees were, $20,000. $3,000, by the way, was not the full amount through April 3rd, as Mr. Hersey suggests, but we didn't get to that. We didn't get that far.
Well, how do we deal with Judge Lee's earlier finding and the magistrate's, I guess, subsequent finding that no fees should be awarded?
Well,
Judge Polo just sort of undoes all this because she has a different view.
I don't think that's an accurate. I don't think that's exactly how it worked. So we get a ruling finding Mr. Hersey in contempt and giving us our requested relief, which was that he has to produce both documents that enable my client to determine every year, both documents that enable my client to determine if he's complied with the insurance requirements. He takes exceptions, and Judge Lee grants the exceptions and sets aside the finding of contempt, and we take no appeal. And we've not contested that. We've not asked that he be held in contempt. We've not asked for anything related to that. Judge Lee does not find that our action was frivolous. She made no such finding. In fact, I had to do a motion for a hearing because she had denied fees, and she changed it on rehearing and allowed us to seek fees under 6116. So now we're in a position where, you know, we've gone to this hearing, we've asked for some relief that we received. That relief's been taken away. We opt not to appeal Judge Lee's ruling. We're just going to get our fees, which at that point were considerably increased by Mr. Hersey's filing of the exceptions and having to do memorandum of law for those and so forth, but still not nearly where they are today. So we go back and we start working on getting fees. That causes us to have discovery issues and to incur fees regarding discovery. Ultimately, Mr. Hersey agreed that he had the ability to pay and should be paying all the fees except if there was a non-financial reason for those fees to be denied. And we go to a hearing and he suggests that the fact that we lost on the motion for contempt means we should have known that we were going to lose, and therefore none of the fees that were incurred thereafter were appropriate
Well,
as a matter of law.
What are we to make of Judge Lee's ruling, though, that basically is a pronouncement that no fees incurred after April the 3rd will be reasonably incurred? And I know you're seeking them under 6116, where it's just a question of need and ability and reasonable fees. And she's taken a legal position that there none would be reasonably incurred. Are we just to ignore that? What are we supposed to do with that?
Judge Lee did not make that ruling. That's the general magistrate
Well,
that's the general magistrate. That's what we took exceptions to. And I think that that's a legal question. And Mr. Hersey suggested that Judge Polo, he suggests two kind of incorrect ways that Judge Polo looked at this. And one was that she shouldn't have disturbed any factual findings by the general magistrate. But the only factual finding she changed was this, you know, really red herring of a finding that doesn't matter a whole lot, but that this life insurance policy was unencumbered. And of course it wasn't. I mean, there's admissions by Mr. Hersey's counsel. I can point you to the record. It was encumbered. It just wasn't encumbered so much
Right.
that it affected his
well, for all
obligation.
intents and purposes,
Right.
that was a non-issue with regard to your client. Yeah.
But that's the one factual determination she disturbed. As a legal matter, she made the finding that the general magistrate, having made the factual finding, the general magistrate made the factual finding that the former wife, and I'm reading from it, the former wife has not engaged in bad faith, excessive litigation, or other misconduct. So the general magistrate actually found there was no bad faith, there was no misconduct, there
The
was
GM
no,
also found that all the fees after the compliance were not reasonable, which is a separate sentence immediately preceding the one you just read.
the general magistrate found that, hold on. Not, yes, the general magistrate found they were not reasonably incurred, which is, remember, this is
Under
this is-
6116.
Right. Remember, this is an entitlement hearing, not an amount hearing. This is a hearing where the general magistrate is finding whether or not we're entitled. And she's finding that because ultimately we lost,
Mhm.
because ultimately the court ruled in Mr. Hersey's favor, we, I guess, should have known that. And therefore we shouldn't have proceeded to our hearing. And that brings me to the other finding which Judge Polo made, and Mr. Hersey seems to suggest that she was reversing or undoing or changing what.
Well, it looks like it, to be honest with you, and that's a big concern.
Right. She clearly disagrees with Judge Lee. She makes no bones about it. She would have ruled differently. But she also specifically says she's not reversing Judge Lee.
Well,
What she's doing is she's saying reasonable minds can differ. So it wasn't frivolous for the wife to pursue the hearing. So
and all these extrajudicial comments that are uncalled for and unnecessary have definitely muddied this case. Because while she said all the things that you've said, it sure looks like she was reversing her, which we all know she cannot do.
correct. And I agree with you completely. And it doesn't, you know, it certainly didn't add a whole lot to have that level of discussion of the subject, but I think it's important to remember that the ultimate decision that she's making is that it wasn't frivolous. It wasn't frivolous for us to proceed to ask the court to essentially what we were seeking, and it's clear from the transcript, I think it's clear from the brief, what we were seeking was we were seeking the court to make it clear that Mr. Hersey had to provide us 2 pieces of information so that my client in the future would be able to know whether or not he was in compliance, because ultimately that's what's required. And was it frivolous for us to do that? Having received similar relief from Judge Silver 6 years prior, where Mr. Hersey was found in contempt after having complied with the court order and ordered at that point to regularly provide this proof of life insurance, I don't see how it could be frivolous to seek the same sort of relief again, where we're saying, look, you ordered him to provide proof of life insurance. He didn't provide it for 6 years.
I don't think they're arguing frivolity here. I mean, or if they are, it's a half-hearted argument, because because there's nothing to go on with that. The GM makes that the most recent GM finding that Judge Polo ultimately dispenses with includes that finding that this, hey, look, this wasn't frivolous, and certainly Judge Polo didn't say it was frivolous, and Judge Lee never said it was frivolous. I don't think anyone is really pursuing kind of a Rosen level thing. I think the issue here is, look, having made a determination that once he's in compliance with the contempt motion, there's nothing, it's moot, it's done. There's no need to go forward and do any more litigating. Are there any fees incurred after that point reasonable? And we've got a prior circuit judge's ruling that, although it may not speak directly to that issue, certainly makes a definitive ruling about when contempt becomes adjudicated and moot. And we've got a subsequent GM applying that ruling and saying, well, look, anything that comes after that just wasn't reasonable. I think that's what we're stuck
Right.
with.
And that second finding is incorrect as a matter of law, because just because you lose, so I'm talking about frivolity because that would be a basis, if there were frivolity, that would be a basis to deny the fees.
Right.
There is no frivolity. And so as a matter of law, if there's no frivolity, there's no intent to harass, there's no misconduct, there's nothing wrong, we're simply proceeding with our case, seeking a relief that we ultimately are unsuccessful in obtaining because Judge Lee vacates the general magistrate's report. So we get our relief, but then it's vacated. But the fact that we're going forward with this, if it isn't frivolous, if it isn't misconduct, there's absolutely no basis to deny the fees under 6116.
Sure there is. I mean, a reasonable jurist could say, look, once the contempt is in compliance, and given what we're talking about, which is really, we're not even talking about payments themselves. We're talking about providing proof of insurance that would cover payments if they weren't made. So once the contempt has been complied with, this just isn't reasonable. There's no need to litigate further. There's no need to go farther with this. You've gotten your compliance. You've got your 2 documents. Go forward and live your lives. I mean, I don't see why a jurist couldn't make that within the rubric of 6116 and just say,
And
look,
quite
after
candidly,
that point,
to add to that is the only reason we're here is because the fees are 34 grand and not 3 grand.
Yeah, but the fees,
If they were 3 grand, we wouldn't be here.
Maybe at the time, there were many places where this could have been resolved. Mr. Hersey took those exceptions from the general magistrate's report, with though it found him in contempt, all it ordered him to do as a result was to provide us those 2 pieces of paper every year. And so we could have resolved it at that point, but we didn't. He took exceptions that made it very expensive. And I think
and you did have an expert to provide evidence as to the reasonableness of the fees, the number of hours spent, and the work done, right?
I don't even recall. I don't think there was any issue I don't think there was an issue about, and Mr. Hersey hasn't raised any issue other than suggesting that we should have known that we were going to lose.
Mhm.
and therefore we shouldn't have proceeded. And that's just not the standard under 6116. And you know, if we, I don't know how to say this better, but you know, this is a suggestion that we should have known, even though
I'm
we got
not,
a different
respectfully, Ms. Ware, I'm not reading his argument that way, or I'm not hearing his argument that way. I'm not hearing it as a Monday morning quarterback. Well, they should have known. They should. I'm hearing it more as a definitive pronouncement. Look, there's a pronouncement that everything after this became moot.
But
And
that
so once it's moot, there's just no reason to litigate. That's how I'm understanding their argument.
But he's talking about we shouldn't have proceeded from the time we should have known that was going to be the ruling through getting that ruling. Once
Well, but
getting that
you had
ruling-
Judge, fair enough. So after Judge Lee's ruling saying, look, it's moot, that would be arguably a cut. Like, look, at this point, we now know Judge Lee has weighed in. She said that this is now moot as of this point. And therefore, you know, you're right. Maybe there is a space there between when Judge Lee rules and when you had compliance. Then maybe there was some need for fees.
And
But
that's,
anything that accrues after that.
and that's the only period that we're talking about, because everything that accrues after that is Mr. Hersey's attempt to prevent us from getting those fees. Everything after that is Mr. Hersey's, our attempt to get the fees, and Mr. Hersey's attempt to prevent us from getting those fees. So the period of time that Mr. Hersey is complaining about is he's suggesting we should have known, we should not have proceeded. Again, I think that to find this, you have to find that our proceeding was frivolous, and the general magistrate found that it was not.
Mm-hmm.
We shouldn't have gone to court on that day and asked the general magistrate to order Mr. Hersey to provide us those 2 pieces of paper every year. And then we shouldn't have, I guess, then we wouldn't have had the exceptions that Mr. Hersey filed. But there's been no finding that it was crazy or frivolous or unreasonable for us to simply ask the general magistrate to hold Mr. Hersey in contempt and order him to provide us those 2 pieces of paper every year. She did both.
The problem you find yourself in is where, though, is that for better or worse, your subsequent judge, that wasn't the reason that she latched in on. Her basis, to me, reads pretty clear. I don't agree with Judge Lee's substantive ruling on this. And
Right.
I think that's the problem that you've got to contend with here.
But I think it's really not a problem. I mean, it's a little unusual. I get that. I get that the language sounds strange, but what she's saying is our proceeding wasn't frivolous. In other words, she too, had she been the attorney, I presume, would have done as we did and proceeded on contempt because the compliance by the life insurance company wasn't the compliance by Mr. Hersey. That's her view. She would have proceeded. She's saying not frivolous, not unreasonable. She's not suggesting that Mr. Hersey should be found in contempt or that Judge Lee's order should be undone in any way. And Mr. Hersey's suggestion that that's the result of her ruling is misplaced. She, in no way, if you look at the order, if you look at the ruling itself, nowhere does she say, Mr. Hersey, I'm finding you in contempt, or I'm ordering some sort of sanction or anything. All she's saying is reasonable minds differ, i.e. it was not frivolous. It was not crazy to go ahead with that hearing when at that point, remember, we did not have Judge Lee's ruling. We did not know we were going to lose. I thought we were going to win. We actually won in front of the general magistrate, and then we lost in front of Judge Lee. Under 6116, you're not stuck with only getting fees if you win. I mean, if it were totally baseless, frivolous, then the fees could be denied. But the general magistrate's explicit finding was that we engaged in no misconduct. This wasn't unreasonable.
I don't think Judge Lee disturbed that. Like I said earlier, no one has stated it was frivolous. The only ruling that the GMs are having to contend with is when Judge Lee came and reviewed the exceptions and said that, look, at this point, the contempt, there can't be a finding of contempt because he had complied beforehand. So
Right.
if that's what you've got, then you come back on rehearing and seek and say, hey, wait a minute, you need to do reserve on fees, and that you get your amended order, and away you all go. I am disturbed though by the way that Judge Polo treated a colleague's prior ruling on an issue, because I can't read it any other way than taking her at her word. I disagree. Well, you're suggesting what she's disagreeing with is a finding of frivolity, but Judge Lee made no finding of frivolity. So that's not what she disagreed with. She disagreed with what Judge Lee did.
I'm sorry, if I said that, I misspoke. I'm not suggesting that she disagreed with a finding of frivolity. Judge Lee did not make a finding.
Okay, okay.
She disagreed with Judge Lee's ruling, which led her to decide that our pursuit of the case was not frivolous.
Right. The ruling on the issue of when does contempt cut off? When is it no longer necessary? Right. But she was not at liberty to disagree with that. Would you agree?
I would agree that there are aspects of her ruling that were not helpful to either side in any way, and it was pretty vigorous. But the ultimate question is, was it unreasonable for us to proceed when we did not have Judge Lee's ruling? We did not know what the outcome was going to be. What we were seeking was very consistent with what the previous judge, Judge Silver, had done in a similar case and found Mr. Hersey in contempt. And we were seeking to have sort of a fix to this problem and have Mr. Hersey ordered to provide both of those two pieces of paper so that we would know every time that he had the appropriate life insurance without having to come back to court. So was it unreasonable for us to do that? Judge Lee did not find it was unreasonable for us to do that. She just decided that we weren't entitled to that relief. We have not appealed that. We have not complained of it. We weren't asking Judge Polo to undo it. What we were asking Judge Polo to find was that it wasn't unreasonable for us to go forward. And yes, she went beyond what she needed to do and said, yeah, she would have done something differently. But ultimately she's saying, you know, you didn't do something crazy. I would have agreed with you if I'd have been on the bench. Is that an appropriate thing for her to do? I mean, I didn't ask her to make that finding. I asked her to see that what we sought was a reasonable way to go. And there's no reason to deny us fees merely because ultimately Judge Lee did not agree with the way that we saw the case. And, you know, in family law cases under 6116, that is absolutely the law. And, you know, Rosen says, and I had it right here a second ago, Rosen says you can deny fees. I highlighted it. You can deny fees where a court finds an action is frivolous or spurious or is brought primarily to harass the adverse party. The trial court has the discretion to deny a request for attorney's fees to the party bringing suit. I would think that would also apply to a portion of the action. So if you're seeking fees and a portion of the action was frivolous or spurious, you could deny it. But ours wasn't. Ours was made in good faith. The general magistrate specifically found no bad faith. Ours was made in good faith with an honest attempt to solve a problem for the future. We lost, we accepted that. So yes, Judge Polo said more than she needed to say, but what she needed to say was our position was not unreasonable. And she certainly said that. And she made the finding that having the general magistrate having found that the action wasn't made in bad faith for harassment and so forth. And I'm, you know, not reading exactly the language from the general magistrate, but the general magistrate basically said there was no bad faith on our part. There was no misconduct on her part. And as a matter of law, if we weren't engaging in misconduct, if our action wasn't frivolous, if our pursuing those fees, I mean, pursuing that result that we were unsuccessful in getting was not inappropriate, we're entitled to our fees. And that's what Judge Polo ruled.
Ms. Weir, you're at your 20-minute mark.
Okay, thank you very much.
Thank you. If you could put your mic on mute, thank you. And Mr. Hersey, 5 minutes of rebuttal.
Thank you, Your Honor. I wanted to first address this issue where Ms. Ware says that they were trying to have the court order that I provide certain two pieces of paper in the future. That was never brought up in any pleading or motion or anything. She just kind of threw that in. And you can't seek contempt or future compliance. Now, she also says the general magistrate did not find bad faith or whatever, but if you look at the general magistrate's corrected report and recommendation, that was with regard to the former husband's request for attorney's fees, because it's well settled that you cannot order someone to pay the other person's fees if they have the superior ability to pay, unless there's bad faith or a pattern of excessive litigation. So in her order, she said, no finding of bad faith or pattern of excessive litigation is made as to the former wife. Accordingly, the former husband's request for fees is denied. And it was based on, she didn't find bad faith or pattern of excessive litigation.
Mr. Hersey, if you don't mind, you had said in your earlier argument that you had paid all the wife's fees up through April the 3rd.
We had.
You said that. Ms. Ware contests that. And you heard her say, that's not exactly right. My question to you is, if it is, as you say, all fees were paid through April the 3rd to the wife, what the heck was, I mean, what happened after April the 3rd that ran up $34,000 in fees? What were you fighting about?
Exactly.
Well, you were fighting about fees though, weren't you?
No.
Ms. Ware was pursuing you to get what she perceived to be the balance of the fees that were owed for activities that occurred before April the 3rd, the way best I understand it. So help me understand this, because I don't.
No, we had paid all the fees that she had mentioned in court that were accumulated up to April the 3rd. And here's the thing. On April 3rd, if in fact the documents that we provided on March 31st, if there was any ambiguity in it, which I don't think there was, that was certainly cured on April 3rd, when the former wife received the entire file from MetLife pursuant to their subpoena. At that point, there was compliance. There was no issue. There was nothing more that the wife could ask for. She was made whole. She got what she wanted.
Question about whose compliance. I mean, the wife asking MetLife for the information does not absolve you of your obligation.
Well, Your Honor, I think we met our burden by the documents that we furnished to the former wife, and she never complained and said, "Hey, I don't think this is right." I don't think there was any ambiguity. It states that there was a $150,000 policy with the wife as former wife as beneficiary, but at that point, and even after they got the MetLife file, at that point, there was nothing else. The former wife had no personal stake in the outcome of the litigation. The litigation should have stopped there. The attorney should have said, "Hey, look, we got everything we wanted. He's got the insurance. There it is," and cut it right there. And so we had to continue to pursue it. And then we made our motion to dismiss based on mootness at the contempt hearing, which was denied. So if Ms. Ware had said, "Hey, look, on April 3rd, we got real proof here. Now there's no ambiguity, no question. He had the insurance. Look, there's nothing else for us to gain here." So the former wife certainly had no further stake in the outcome of the litigation. And in fact, the only one that had was Ms. Ware to continue to run up $37,000 of fees after that. Now, we talk about there was no frivolity. Well, the general magistrate never used the term frivolous or frivolity. But if you look at, Ms. Ware cited a case that dealt with frivolity. And if you look at the definition of frivolous, it is not having any serious purpose or value. And apparently that's what the general magistrate found, because she figured, what were they looking for after April the 3rd, when they knew that he had the insurance and there was nothing else to litigate?
I don't know, Mr. Hersey. I think that's such a charged finding, particularly in family law proceedings, that asking us to try to read between lines and discern frivolity finding that is expressly not made and in fact disclaimed later on by a subsequent GM, I think is maybe stretching it too far.
I understand.
The argument, I don't think that detracts from your argument that it wasn't reasonable. But I don't think that just because it was, your argument may be that it was not reasonable to continue litigating after you got compliance. That's one argument, but I don't think that precludes a finding that says, well, yeah, that's not reasonable, but it wasn't frivolous either. I think both of those can be merged together.
Yeah, and at the December 4th hearing before Judge Polo, page 1099 of the record on appeal, Ms. Ware tells Judge Polo, and the fees are huge. They're ridiculous. They're outrageous. It is unacceptable. And they were. And if there were any fees remaining after April 3rd, Ms. Ware sure didn't tell us about it, because if she would have said, hey, look, I still got another 1,000 here outstanding, we would have paid it. Litigation should have ended April 3rd. There was nothing else for the wife to gain from any continued litigation except to hold the former husband in contempt and to run up attorney's fees. It's just such a waste of resources.
And Mr. Hersey, you're going to have to wrap it up, please.
Yes, sir. Thank you so much. And as I said, on issue number 2, I rely on my brief.
Thank you both.
Thank you. Stay safe.
Thank you. Our next case on our docket this morning is R.J. Reynolds versus Durant's